Колеги, ми продовжимо робочий день. Тема наступної прес-конференції.
The next press conference is the collection of evidence related to international humanitarian law violations. Our speakers are Mr. Wayne Jordash, headquarters managing partner, and Oleksandr Pavlichenko, deputy director of Kharkiv Advocacy group.
My name is Wayne Jordash, as you've heard, the managing partner of Global Rights Compliance. And I wanted to speak today at the Centre about basic investigation standards, which we as an organization have compiled. It is an easy-to-use guide for civil society organizations to be able to meet minimum standards for investigating international humanitarian law violations. The manual is for a variety of actors who wish to engage in this work and will provide standards which range from the very, very minimum all the way to more complex guidance for those who wish to engage in more professional type investigations. And as such, the structure of the guidance is as follows. First of all, the manual starts with a section dealing with the very basics of what a minimum standard investigation should provide. It considers the various ways in which civil society can engage in this work, from the role of a first responder, that is an organization which is trying to collect evidence of international humanitarian law violations, but is not doing so in order to act as a professional investigator, but is in fact looking to collect the information to pass to professional investigators such as the International Criminal Court. And this guidance is very much geared to those organizations who are currently looking to cooperate with the International Criminal Court and send their information about events and violations to the International Criminal Court. On the other hand, the guidance also contains more complex guidance concerning standards which professional investigators would meet. This is for civil society organizations who decide that they wish to move beyond the role of a first responder and act as professional investigators instead of relying upon the International Criminal Court or instead of relying upon domestic investigators or prosecutors whilst they collect the evidence and then consider what remedies to seek on behalf of victims. And so just very quickly, the guidance contains the following. First of all, it contains the basic principles which underlie the assessment of evidence at the International Criminal Court and also in many domestic states. The burden and standard of proof, what admissibility means at the International Criminal Court. What rights do victims and witnesses have to confidentiality? What rights do accused have for exculpatory evidence? And then we deal with 10 basic investigation principles, the very basic principles which are essential to any reasoned and reasonable investigation. 1, do no harm. 2, maintain minimum standards. 3, maintain impartiality and objectivity. 4, be confident of your own competence. 5, focus on the information and the evidence, not law or opinion. 6, record, collect and preserve all information. If you're a first responder, you need to be collecting all information that could reasonably be relevant. If you're a professional investigator, the investigation is likely to have developed further, you're likely to have focused on a particular theory, and you will collect evidence in a more narrow and focused way. Importantly, number 7 of the basic investigation principles: implement an organized system to record the investigation steps. And we spend a lot of time in this manual identifying the precise recording system that any investigation needs to develop. 1, to protect the integrity of the investigation, and 2, to protect the confidentiality and security and privacy of any victim or witness. If you look in the guide, you will see a model record system which will enable any investigator, any NGO organization to develop a good system to assist their investigation. Number 8 of the basic investigation principles: ensure confidentiality and protection of witnesses and sources. It is sometimes, unfortunately, a dangerous business being a victim or a witness. We provide you in this manual some basic minimum standards on how to ensure confidentiality and the protection of these vulnerable persons. Number 9, always implement a chain of custody. And number 10, have in-house guidelines and make sure you follow them. So, in brief, please look at these basic investigation standards. They will assist any NGO organization in meeting their difficult task of collecting, preserving, and recording humanitarian law violations in order to ensure accountability and justice. They are a minimum guide and will provide you with everything from the collection, how to deal with a crime scene, how to deal with physical evidence, how to deal with documentary evidence, and how to deal with testimonial evidence. Thank you very much.
Good morning. Our organization, Kharkiv Human Rights Protection Group, and coalition of NGOs monitoring violations of human rights in Donbass and occupied territories, had prepared the report about violation of human rights in occupied territories. And this is about the cases of tortures, about kidnapping, about violation of human rights of those people who stay in the penitentiary institutions or in custodies. That is, we have prepared materials which might be submitted to the International Court on Human Rights, and currently our commission is at the stage when we come to the collection of evidences and to the stage of documenting all those cases. And now we are at the stage when we would like to share our work, our experience with global rights compliance organization. The manual which Mr. Jordash presented is of primarily importance for those organizations which are not professionals in collecting evidence and confessions of those people. We are not professional lawyers. For example, our organization, Hive Human Rights Protection Group, we are more or less professional in law, while another 17 organizations which joined into a coalition, they have no experience in this, and the Global Rights Compliance Organization and the experts from this organization, they provided a lot of assistance to us in their manual. today our organization is actually forced to deal with the violations of human rights, to document them. And here we have to deal with the crimes which were committed during Maidan events, in course of Crimean occupation, and in course of the occupation of Donbass. And we have prepared our report, which is highlighted survived in the hell, and we will disseminate this report at the UN level among the General Assembly members. And while this report has a rather impressive number of proofs, collected evidences, but at the same time it requires further, all those cases require further investigation. As for the manual which we mentioned today, it is very detailed methodology which provides many practical details to the work of those who will document the cases. It introduces some new elements even to the national standards of investigations. Standard number 9 about the chain of custody, and we have to think carefully how to translate properly this standard into Ukrainian language, to describe it and to reflect, to reproduce the meaning of this notion properly in Ukrainian. Also, the impunity in violation of human rights creates preconditions for continuation of that violations, while our objective is to put an end to the violations of human rights in the east of Ukraine. Our coalition, Justice for the Sake of Peace in Donbass, one of our purposes is to prevent violation in future and to seek for justice for those victims who suffered from violations of human rights in Crimea and during Maidan events. And we are very happy that we have such good materials which support our work, as those materials which Mr. Jordan presented today. We believe that the Roman Statute should immediately start to work in Ukraine and be applied to all the events beginning with November 2013, irrespectively of the additional conditions set by Ukrainian law on ratification of this statute, and about changes in Ukrainian legislation. But I believe that a Ukrainian legislative base is sufficient for implementation of the international law norms, and Ukrainian lawyers can facilitate efficient implementation of such international norms. And I believe that international humanitarian law may become a real shield protecting further violations of human rights in the sovereign territory of Ukraine. Now questions, dear friends. Bogdana Kostyuk, Radio Liberty. Yesterday, Amnesty International made a statement that investigation of Nadia Savchenko's case, who is a member of Ukrainian parliament and officer of the armed forces of Ukraine. So they made a statement that this case should be investigated impartially without excessive politicization. Whether this should be applied only to Nadia Savchenko, taking into account what's going on in Donbass, whether this should be applied just to the prisoners in Donbass or the political prisoners which were kidnapped from Ukrainian territory and which are now detained in Russian territory, actually.
The answer to that is that all investigations into violations of international human rights or humanitarian law need to be investigated impartially and objectively, and the state has a irrevocable obligation to do that, whether the case is high profile, like the one you mentioned, or whether it's of a market seller in a town in the east who is not known by anyone other than their immediate family. Human rights are for everyone, not just the chosen few, and those human rights involve and must involve an obligation by the state to investigate all of those violations and find accountability and justice for all victims, whatever their nationality or political belief.
Я можу додати щодо вашого питання, пані Богдан.
I would like to add, in answering your question, Bogdana, that Ukrainian side had to carry out proper investigation about kidnapping of the officer of Ukrainian armed forces. And actually, as of today, those who committed that crime, who kidnapped that officer, they now carry out so-called investigation in Russian Federation. My point of view is that the crime was the crime was committed when they kidnapped the officer of armed forces, and this fact was not properly investigated by Ukraine, because kidnapping is a crime, and this crime was committed in course of when this person was fulfilling its duty as the army officer, and then she was unlawfully transported in the territory of neighboring state and condemned in committing crime. As of today, we observe that the terrorist kidnappings continue, and actually when the opposite party claim that they are investigating something, that's not true actually.
Oleg Shevchenko, the question is to both speakers. Please tell what number of cases do you have in your list? How many cases do you have in your list, and what is the result that you expect to receive? And when will the second stage start? You collected evidence. When will we see the result of this work? I believe that you've been working on that for more than 2 years. The collection of evidence started last year. So basically the product that I showed, that report, is the result of the last year's work. And I can tell you that we are collecting documents and interviewing persons who were the victims. These are not the witnesses, just the victims, and we have, when the report was made, we had 162 cases documented. We put this information into the special database. It's described in the report, and that is the database which is used by police services of different Western countries to create the special information flows to find out how the information corresponds that is received from one witness, for example, corresponds to the information which is received from another fact of the event. We have more and more evidence like that. We put them into the database, and what's reflected in the report, we are just quoting some fragments of the interviews, and that illustrates this or that violation. When it's about the parades of the prisoners, those who participated in such parades, so to say, they talk about their impressions, but the interview takes a lot of time, and all that information is downloaded into this database. And today, I would like to say that that's just the information. We are now working on turning it into the evidence. Thank you. The People's Movement of Ukraine, Oleksandr Semen. My question is, from the point of view of the international criminal law, how can you explain the actions when the money which is paid by the president to the budget of Russia, I mean the Lipetskaya chocolate factory, the taxes which are paid to Russia are used to buy the weapons. I will start answering. I believe that Wayne did not understand what this question is about. We all know what you are talking about. We know that the President Poroshenko, while he is still the owner of Roshen, one of his factories is on the territory of Russian Federation in Lipetsk, and the factory pays taxes which is used for armaments, whether that corresponds to the norms of the international criminal law. In the context of the international criminal law, that is not considered. So this is not the topic for this press conference. Let's not discuss that issue. Thank you, colleagues. We will finish our press conference here.
Here in the nearest future. Thank you.
Thank you.
Так.